There are certain ideas that we find detestable, concepts we find repulsive, and even some actions we cannot abide. Do we have the right to tell others that they must live by what we find acceptable? How many dystopian novels are based in the idea that only approved thought is allowed in society? Benjamin Franklin, writing as Silence Dogood, said, "Without freedom of thought, there can be no such thing as wisdom, and no such thing as public liberty without freedom of speech, which is the right of every man as far as by it he does not hurt or control the right of another, and this is the only check it ought to suffer, and only bounds it ought to know." What will you do to protect public liberty? What will you allow, not because you approve, but because you recognize the rights of others to live differently than you do? We'll discuss that next on the Constitution Study.
One thing you have to know wherever you make your stand came from a long through line of everyday Americans.
Hello there, everyday Americans. Welcome back to the Constitution Study. This is where we read and we study the Constitution and we teach the rising generation to be free. I'm glad you could join me. As always, please, you want to find out more, you can head to constitutionstudy.com. You can ask questions, you can sign up for the newsletter, you can read the articles, watch the videos. All of it's there, and I'll talk a little bit more about that at the end of the video. But right now, I want to talk about this idea of public liberty. The question in the case Carpenter versus James seems to be quite simple. Can the state of New York force Emily Carpenter to do business in a way that violates her conscience? I refer to freedom of conscience because of the breadth of the rights at stake in this case. Now, Emily Carter runs a wedding photography business, Emily Carpenter LLC. Now, she brought suit against the Attorney General of New York, Letitia James, the interim commissioner of the New York State Division of Human Rights, and the district attorney of Chemung County, New York. Now, she's seeking preliminary injunction to prevent New York's public accommodation laws from being enforced against her. Plaintiff initiated the present suit after learning about New York's public accommodation laws. She believes that those laws, quote, threaten her ability to operate her business according to her faith, close quote, and, quote, restrict what she could post on her studio's website and social media sites and what she could say to prospective clients, close quote. There are 4 provisions in the dispute, 3 contained in the New York Human Rights Law, and 1 contained in the New York Civil Rights Law. Since Ms. Carpenter cited 4 provisions of the New York State law that violates her rights, let's start by looking at them. The first provision is what plaintiff refers to as the, quote, Accommodation Clause. New York's Human Rights Law provides, quote, it shall be an unlawful discriminatory practice for any person being the owner, lessee, proprietor, manager, superintendent, agent, or employee of any place of public accommodation, resort, or amusement because of the race, creed, color, national origin, sexual orientation, gender identity or expression, military status, sex, disability, or marital status of any person, directly or indirectly to refuse, withhold from, or deny to such person any of the accommodations, advantages, facilities, or privileges thereof. Plaintiff does not dispute that her business is a, quote, public accommodation, subject to the law. While Ms. Carpenter does not dispute that her business is a public accommodation, the first thing we should do is define what a public accommodation is. In simple terms, the word public means of, relating to, or affecting all the people or the whole area of a nation or state, as in public law, of or relating to a government, or of or relating to or being in the service of the community or nation. For something to be public, it must be publicly owned or in the service of the community. And the definition of accommodation is something for the convenience or to satisfy a need, such as lodging, food and services, or traveling space and related services, usually used in plural. For example, tourist accommodations on a boat, overnight accommodations, or a public conveyance, such as a train that stops at all or nearly all points. So how does a privately owned photography business become a publicly owned convenience to satisfy a need such as lodging or transportation? The answer is lawyers. When I researched the term public accommodation, I found that most legal dictionaries define a public accommodation as anything that was open to the public. I did find one reference to a 2009 case, Bishop versus Henry Modell Company, where the attorney for Mr. Bishop paraphrased the law as this. A place of public accommodation is defined as an establishment either affecting interstate commerce or supported by state action, and falling into one of the following categories: a lodging for transient guests located within a building with more than 5 rooms for rent, a facility principally engaged in selling food for consumption on the premises, including such facilities located within retail establishments and gasoline stations, any place of exhibition or entertainment, any establishment located within an establishment falling into one of the first 3 categories, and which holds itself out as serving patrons of that establishment, or any establishment that contains a covered establishment and which holds itself out as serving patrons of that covered establishment. Now, interesting, the court, however, they did not agree. The defendants argued that the Model store is not a public accommodation within the meaning of the statute. We agree. The text of Section 2000A does not explicitly include retail establishments, and case law confirms that retail stores are not places of public accommodation within the meaning of the provision. Over the course of a 41-page complaint and over 80 pages of briefing in opposition to defendant's motion to dismiss, plaintiff's sole factual allegation to support this argument reads in its entirety as follows: that Model stores serve food to the public or provide entertainment for the customers. So by the standard of the law, in the opinion of the Bishop v. Model Court, Ms. Carpenter's business is not a public accommodation. It's not a lodging. It's not principally engaged in selling food. It's not a place of entertainment. And although she may have an office as a wedding photographer, the service she provides would happen outside of her offices. Even if we consider a photography business a public accommodation, those laws are in violation of the Fifth Amendment to the Constitution of the United States. No person shall be deprived of life, liberty, or property without due process of law. Most people, when they think of property, think of land or things. However, James Madison had a more detailed view. This term, in its particular application, means that dominion which one man claims and exercises over the external things of the world and exclusion of every other individual. In its larger and juster meaning, it embraces everything to which a man may attach a value and have a right, and which leaves to everyone else the like advantage. In the former sense, a man's land or merchandise or money is called his property. In the latter sense, a man has a property in his opinions and the free communication of them. He has a property of peculiar value in his religious opinions and in the profession and practice dictated by them. He has a property very dear to him in the safety and liberty of his person. He has an equal property in the free use of his faculties and free choice of the objects on which to employ them. Yes, Ms. Carpenter has a property in the merchandise she owns, including the cameras, lighting, and other equipment for her business. She also has a property in her business, since she exercises exclusive control over it and attaches value to it. She has a property in her opinion and the ability to profess and act on it. Lastly, she has a property of the free choice of the objects on which she employs her skills as a photographer. Since these public accommodation laws deprive her of control of these properties without a governmental process that protects her rights, due process, these laws violate her rights protected under the 5th and 14th Amendments of the Constitution of the United States. The second provision is the denial clause, which makes it unlawful to publish, circulate, issue, display, post, or mail any written or printed communication, notice, or advertisement to the effect of any of the accommodations, advantages, facilities, and privileges of any place of public accommodation shall be refused, withheld, or denied to any person on account of race, creed, color, national origin, sexual orientation, gender identity or expression, military status, sex, disability, or marital status. The third provision is the Unwelcome Clause, which prohibits a public accommodation from publishing, circulating, issuing, displaying, posting, or mailing any written or printed communication to the effect that the patronage or customer of any person of any or purporting to be of any particular race, creed, color, national origin, sexual orientation, gender identity or expression, military status, sexual or marital status, or having a disability is unwelcome, objectionable, or not acceptable, desired, or solicited. The denial and unwelcome clauses blatantly violate Ms. Carpenter's free speech rights. Now, many people, including Ms. Carpenter's lawyers, jumped right to the First Amendment free speech clause. Of course, all of them ignore the actual language of the First Amendment. Congress shall make no law abridging the freedom of speech. Yes, many claim that the 14th Amendment incorporated the First Amendment to the states. That's patently ridiculous since only the national legislature is called Congress. What this law does violate is the freedom of speech and press clause of the New York State Constitution. Every citizen may freely speak, write, and publish his or her sentiments on all subjects, being responsible for the abuse of that right, and no law shall be passed to restrain or abridge the liberty of speech or of the press. Since this law prohibits Ms. Carpenter's ability to speak, write, and publish freely in regards to her sentiments on same-sex marriage, it violates the state's constitution. The fourth provision is found in New York Civil Rights Law, Section 40C. That statute reads, "No person shall, because of race, creed, color, national origin, sex, marital status, sexual orientation, gender identity or expression, or disability, as such term is defined in Section 292 of the Executive Law, be subjected to any discrimination in his or her civil rights by any other person or by any firm, corporation, or institution, or by the state or any agency or subdivision of the state." That's New York Civil Rights Law, Section 40C2. All persons within the state shall be entitled to the full and equal accommodations, advantages, facilities, and privileges of any place of public accommodations. Apparently, when the law states that no person shall be subjected to discrimination, that does not include people who disagree with the politically acceptable standards in Albany, New York. See, I've already dealt with the public accommodation question, so here I want to deal with the civil rights question. Now, civil rights defined as the non-political rights of a citizen, especially the rights of personal liberty guaranteed to the U.S. citizens by the 13th and 14th Amendments to the Constitution and by acts of Congress. The basic question is, do you have the right to force others to do business with you against their will? Remember, we're not talking about a law that prohibits photographers from working at same-sex weddings. We're talking about someone being forced to do so against their will. These public accommodation laws force people into involuntary servitude. What's that? Well, involuntary servitude is defined as a condition in which one lacks liberty, especially to determine one's course of action or way of life, or a right by which something, such as a piece of land owned by one person, is subject to a specified use or enjoyment by another. Now, involuntary servitude is strictly prohibited by the 13th Amendment except as punishment for a crime. Neither slavery nor involuntary servitude, except as a punishment for a crime whereof the party shall have been duly convicted, shall exist in the United States or any place subject to their jurisdiction. By passing this law to avoid discrimination, the state of New York has created discrimination. In an attempt to protect civil rights, the state of New York is destroying them. By dismissing all claims against the defendant with prejudice, Judge Frank Gasseri has effectively condemned those who do not agree with same-sex marriage to involuntary servitude to a political cause with which they disagree. Remember, as Benjamin Franklin said, without freedom of thought, there can be no such thing as wisdom, and no such thing as public liberty without freedom of speech, which is the right of every man as far as by it he does not hurt or control the right of another. And this is the only check it ought to suffer, and the only bounds it ought to know. By picking and choosing who has the right to speak, the state of New York and the District Court for the Western District of New York have denied Ms. Carpenter, and by extension all of those who live in that state, the right to speak freely. By establishing an approved way of thinking, the state of New York and this judge have denied freedom of thought, destroyed public liberty, and is thereby destroying wisdom. You may vehemently disagree with Ms. Carpenter's position, and you're free not to do business with her. But if you claim the right to control what other people can say or do, you also are destroying liberty. In his Silence Dogood article, Benjamin Franklin went on, "The sacred privilege is so essential to free governments that the security of the people and the freedom of speech always go together. And in those wretched countries where a man cannot call his tongue his own, he can scarce call anything his own. Whoever would overthrow the liberty of a nation must begin by subduing the freeness of speech, a thing terrible to public traitors." We already know that a majority of the New York State Legislature, the previous governor, and Judge Gasseri are willing to subdue freedom of speech, making them public traitors. Are you prepared to join them? As I was researching this case and the legal basis for it, I really was struck by this idea of involuntary servitude. You know, we know slavery's been made illegal, but we forget that to subject one person to another person's will is involuntary servitude. And that's exactly what's happening to Miss Carpenter and to so many across this country. As a nation, we first used this in an attempt to get rid of a great evil, that of slavery and segregation and discrimination. I'm sure there are still people that are pro-discrimination, they're pro-prejudice, but most of us are not. But what we ended up doing is trading one evil for another. Because we went from an involuntary servitude based on skin color to an involuntary servitude based on thought. We went from, you will do what we say because what you want to do is so evil that the majority of the American people will not stand for it anymore, to, you will do what we say because a politically few say you must do it. Now, I understand there are people that hold ideas that are anathema to freedom and liberty, that I find utterly detestable. But here's an interesting question. Why would you support those people? I was speaking at an event and I was asked about, can you deny someone on the basis of their race? Or can you deny them based on their gender? Can you deny them based on their political viewpoint or what they're wearing? And the interesting thing was people always looking for a way to force their will on others, to force others to serve them in some retail establishment, some retail form. That we were at a restaurant, so could the restaurant be forced to serve you? And it was always looked the other way. Can you be denied service? But the other side of that coin is, can you force them to serve you? And the part that I don't know gets across very well is, if you're a black person, why would you want to support a racist business owner? If you're a Jew, why would you want to support a Nazi sympathizer in their business? Hey, even if you're a homosexual, why would you want to support a business that disagrees with you? See, the other part about these forced levels of actions, this involuntary servitude, is we find it harder and harder to find the people we disagree with because their mouths are shut. See, the problem with bad speech is not, you don't get rid of bad speech by restricting it. You get rid of bad speech by having more speech, finding out who these people are, and ostracizing them. Simply refuse to do business with them. See, rather than forcing them to comply by government, simply force them by starving them of their business. So that's the liberty way of dealing with these things. Now, I know this is a concept that a lot of people have a hard time with, and you want to find out more, well, by all means, head to the Constitution Study, constitutionstudy.com. I've got all sorts of articles, videos you can watch. If you have a specific question, ask a question. If you want, I'll either answer it on my live Q&As or I can answer it on the radio program. That's right, I have a radio program 5 days a week, Monday through Friday, 4 p.m. Eastern Time on the America Out Loud Network, which you can also listen to on iHeartRadio.com. But these are places to go to discuss and debate not only what the Constitution says, but how do we go about living our lives as free people. Now, I'm also next year, I'm going to be doing a Constitution study, an online Constitution study. You can find out more. Just go to constitutionstudy.com/study. You can pre-register. I'm still working on dates and times, but it's starting to settle down. So you're running out of time to pre-register. So check that out. Again, that's constitutionstudy.com/study. You can always find out more. You can always ask a question because this is about learning. It's about reading, about studying, and about teaching. And hopefully, you'll join me here next time for the Constitution Study.